This week we learned Special Counsel Jack Smith's investigation of whether Donald Trump mishandled classified documents apparently includes an audio tape that some consider could be a smoking gun. On that recording, the former president apparently admits he knew he was taking with him documents that had remained classified when he left the White House. So what will his defense do now? Joining me now is attorney Timothy Parlatore. He just resigned from the former president's defense team 2 weeks ago over what he called irreconcilable conflicts with other members of the legal team. Mr. Parlatore, welcome to Meet the Press.
Thank you for having me.
Let me start with there. I mean, you left 2 weeks ago. Mm-hmm. You said it was with, is it advice not being followed? How else would you characterize it?
You know, it's something that I had discussed it on CNN at the time. I had a difficulty being able to do the job that I know how to do. Mm-hmm. I discussed it for specific reasons at the time, but it's not something I really want to expand on too much.
No, I understand. It was conflicts with the lead, with sort of the lead counsel there. Do you feel like the president himself was taking your advice, or could you just not get to him?
You know, I'm not going to be able to get into the conversation, communications directly with him, but certainly, you know, we would come up with strategies, we present it, and we would do what we could.
Let me start with what's your understanding of where the special counsel is? We have the report this morning here at NBC News that says the grand jury's convening this week. What does that tell you?
Well, that's the first thing that I've heard about any action by this grand jury in several weeks. And you know,
what does that mean?
Well, when the grand jury went quiet several weeks back, you know, I kind of looked at it and said, okay, this indicates that either they're coming to a charging decision or maybe they are moving to the stage where investigation is complete and now Jack Smith's going to start writing up the report. Because ultimately, if there are no charges, he's still going to have to write up a report, just like we recently saw from the other special counsels. And so the lack of action, you know, certainly would indicate, you know, the transition.
But now that he's convening, that, in your mind, is more likely to be a potential charging decision?
Not necessarily. I mean, certainly, you know, it could be that they're continuing an investigation into other things. It could be that the reason for the break is that the last grand jury simply expired. And they had to convene a new one. I'm not sure specifically. I mean, I certainly haven't heard of anything you know, new that would you know, require new testimony. I can't imagine that there's anybody else in Mar-a-Lago to testify.
You've dealt with the feds quite a bit. You've done this. You have experience. This is the reason why you were hired. Would you be surprised if the former president isn't charged with something here?
No, not at all. Not at all. I think that this is a case where, you know, you have to evaluate every case based on, you know, what are the facts in the law, and is it something that's provable? But then there's also all of the other atmospherics of, is this something that, you know, from a discretion point of view, is this something where a prosecution makes sense? You know, is it something where it is a slam dunk case where some of these things, you know, could be interpreted a few different ways? And also, when it comes to a specific issue like this, where we are talking about potentially national defense information, is it the type of thing where they want to declassify these things, if they haven't already been declassified, and put them out publicly? You know, there are a lot of additional you know, problems or procedures that you have to go through with that type of a case, and especially when it's, you know, politically sensitive. And I know not a lot of people are going to agree with this you know, parallel, but to me, even if he did a lot of the things that they're saying that he did, prosecuting him, there are the same reasons why you wouldn't want to prosecute him as to why back in 2016 I was of the opinion that Hillary Clinton shouldn't be prosecuted, because there are all of these other problems. You know, you have to, classification is not binding on the jury. Yeah. You have to actually take these documents, show them to the jury, and then prove to them that it constitutes national defense information. In doing so, you're putting
classified things. Exactly. I see where you're going there. We shall see. I want to ask you about these voice memos of Evan Corcoran, a former co-counsel of yours. He had to turn over to the special counsel. I mean, I was surprised to hear these were recordings. It wasn't just other stuff. How damning do you think these voice memos could be?
Not at all.
Why is that?
Not at all. It's, yeah, I have, obviously I'm not going to go to the specific content, but there's nothing that I saw that indicates any difference from any other communication with the client. You know, any time that a client who is not a lawyer, who's not experienced in these things, receives a grand jury subpoena, they're going to ask the standard questions. You know, I sit down with them hundreds of times, and they say, you know, do I have to do this? You know, do they really have the power to do this? Do we have to give them everything? Don't they have to get a warrant? Don't they have to tell us why? Is there any way to stop this? Is there a way to do a motion to quash, or they usually say a motion to squash?
Right.
And so that is the ordinary attorney-client conversation that you want to have with every client, that you would expect to have with somebody who's not experienced, and it's the reason why you have.
But do you
privilege.
think he misled him where these documents were? And do you feel as if the lawyers were misled, that Mr. Corcoran in particular was misled about where these documents would be hiding?
Based on everything I've seen, no. Yeah, he was told where all of the documents were brought from the White House. He searched there. He was not given a much longer period of time. You know, later, DOJ came back to us, and through a whole series of events, we went back to expand the search.
Right.
But that was not something that was in play.
But the fact that maybe it's omission. I mean, one judge apparently in a sealed document. Let me read this from what the judge said here. Notably, no excuse is provided as to how the former president could miss the classified marked documents found in his own bedroom at Mar-a-Lago, according to Judge Howell. It does seem there is a...
Sure.
He seemed to know he had documents he wasn't supposed to have.
So actually, that's an interesting quote that you pulled out, because there were no classified documents in his bedroom. What she's talking about there was this folder that there's been some discussion where the folder said, classified evening summary or evening briefing on it, which is in and of itself not even a classification level. It doesn't mean anything. And here's an important piece. Not only did he know it was there, but the FBI knew it was there. When the FBI conducted the raid of Mar-a-Lago, that folder was there. They saw it. They recognized that it's not classified. It's not something that's subject to any of these. And the FBI left it there. So there were no classified documents in his bedroom. It's one of those things where things get kind of missed in the weeds.
Let me ask you, though, the former president did that town hall when he was asked about it. He again talked about, hey, we were negotiating with the archives.
Yeah.
What are you negotiating? I mean, I don't understand what the negotiation was.
Sure.
Was it financial?
No. The negotiation is over the next 2 years after any president leaves office. They're supposed to go through all of the records, and they're supposed to separate out what is personal, what is presidential. Right. Personal they get to keep. All presidential records end up at the National Archives headquarters in D.C. This ordinarily happens where NARA gets a facility in the town where the president has moved to. So in Chicago for Obama, down in Texas for the Bushes, and all of them are held in that facility. Here, what NARA did instead is they chose not to get a facility like that. They had GSA move everything to his house, and then we're asking him to immediately send everything from his house back up to D.C., where he wouldn't be able to go through them as conveniently.
What did he think the negotiation was about? Just which papers he was going to keep? Because, again, I know he's obsessed with the fact that Nixon got paid for his archives.
Well, the negotiation was over them wanting all the documents back right now, him saying, well, I'm going through them, and they went through the first 15 boxes, they sent those back. And, quite frankly, had NARA come back and said, I have an idea, why don't we just get a facility in Palm Beach, move them there? That would have solved everything right there.
Had you attempted to try to get the president to settle with the Justice Department, and did he not want to, or did Justice not want to?
That's the first time I've ever heard anything like that.
There was never any thought of trying to find a settlement here?
When I was on the team, communications with the Justice Department were minimal. It's not something where everybody talks about whether we're being cooperative and everything, but the Justice Department team that I dealt with was very oppositional and very not open to any conversations, even about simple things. So it's this team, and it's primarily made up of National Security Division people that are not ordinarily criminal prosecutors. It's so different than working with any professional U.S. attorney's office.
Okay. Let me ask you about January 6th. You've seemed to play down the possibility that the former president would get charged with anything on January 6th. The January 6th committee had 4 criminal referrals that they thought could be used to charge the president: obstruction of an official proceeding, conspiracy to defraud the United States, conspiracy to make a false statement, and then the incitement, assisting, or aiding comfort of an insurrection. So you really believe none of those 4 are going to be charges that the former president has to deal with?
Correct. That committee, that was a political committee. When it comes to actually looking into the statute, all of those require them to prove that at the time he knew that all of these allegations of fraud in the election were false.
You mean the fact that every single person that worked for him told him that it was false, that all of those judicial rulings told him there was no there? I mean, how many more times was he had to be told before that is seen as he knew?
If that's what the evidence is, but that's not what the evidence is. He had some people telling him that there was fraud. He had some people telling him that there was no fraud. All the judicial rulings, some of them reached a partial ruling based on the merits, based on not a complete thing.
Yeah.
A lot of them said, it was threshold issues of standing. And so, yes, there were a lot of judicial rulings against him, but none that said, okay, you parties have conducted complete discovery. You've actually gone through everything, and based on the merits, this is what the decision is. And in fact, a lot of those lawsuits at the time, they were seeking these injunctions without discovery. And I think that, in retrospect, had some of those people said, look, we're not seeking an injunction now, we're seeking expedited discovery.
You're saying it was bad legal. He had a bad legal team? Is that what you think?
I think that the way that some of these things were conducted, certainly some of the Sidney Powell lawsuits were conducted, are things that can be criticized after the fact. I think that if they had gone to ask for expedited discovery and said, look, we have an indication of smoke. We don't know whether there's a fire. If there's a fire, it's in the box right there. Tell them to open the box. Let me take a look.
All right.
If there's a fire, I'm going to come back and ask for an injunction. If there's no fire, I'm going to come back and dismiss the case. If they had done that from the beginning, that'd be a different story. But instead, I have smoke. Can you overturn the election? The judge said no.
Tim Parlatore, I had a lot more questions, but we only have so much amount of time. Thanks for coming in,
All right,
sharing.
thank you very much.
Perspective, I appreciate it.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.